am Ben Kitili at the Standard Group Center here in Nairobi. Many thanks for joining us on the broadcast. It's Monday night, the 11th day of December 2017. The big story begins right now. Tonight, the Supreme Court of Kenya has delivered the full judgment to defend why it upheld Uhuru Kenyatta's election in the October repeat presidential poll. Validity of the exercise, candidates, inclusion and withdrawal, arguments for fresh nominations and claims of intimidation of voters occupied the center of the two petitions filed before the Apex Court. The six-judge bench, however, ruled that there was no need for fresh nominations. The withdrawal of NASA flag bearer Raila Odinga was also deemed legally inconsequential. As for the hostile poll environment in certain areas, the court absolved the IEBC or state agencies from blame, terming the chaotic instances politically instigated.
Or by any state agencies. When you take all these factors into account, you reach the conclusion that the body entitled to conduct elections, that is IEBC, conducted the election. It did not turn out any voter, and no state agency hindered the voters from voting at the polling stations.
The Elections General Regulations 2012, submitting that save for a withdrawal by a candidate in any election 3 days after nominations, the election laws do not contemplate any withdrawal. And consequently, the Honorable Raila Odinga's letter of withdrawal as a presidential election candidate amounted to just a mere intention to withdraw with no legal effect, as it had not been communicated via the prescribed form.
Joining me on the broadcast tonight to try and put perspective on these issues are Felix Owore, constitutional and election law experts, as well as advocates Muthomi Thiankolu, not new to you here on the broadcast, and Oliver Kipchumba shall be trying to take the next 60 minutes or so to try and delve much deeper into that full judgment by the six-judge bench of the highest court in the land to try and find out and understand, make Kenyans understand just what are some of those issues. Try to get into as much detail as we possibly can. If I can start with you, Mr. Thiankolu, what is your initial reaction? Of course, Kenyans did know this on the 20th of November. They did, get to hear the verdict of the court of the Supreme Court. But this full judgment, did it have any surprises from where you sit?
Not at all, Ben. And for me, my concern is not whether this judgment is technically correct or incorrect. And the reason I say this is because as a country, we have perfected the art of legalism, which is simply the art of using what we've called on this show clever but dishonest legalistic arguments that do not help our country to resolve the socio-economic and political problems that bedevil our society. I do not see in this judgment, just like I do not see in the judgment that was delivered on 1st of September this year, any serious appreciation of the roots of our political problems and our electoral problems. And while talking on the matter, what I mean, so that we don't sound unduly academic and sophisticated, is the role of law in society is as a tool of socio-engineering, and court judgments should be seen not necessarily from the perspective of their technical merits or demerits, but in terms of the scheme of incentives and disincentives for mischief, the scheme of incentives and disincentives for criminality and malfeasance in general. And I do not see in this judgment, like most 99% of all our electoral dispute resolution judgments, any serious appreciation of the problems we have with our elections, and therefore I don't see the judgment creating incentives that encourage either the electoral management body or the contestants themselves or the political parties or indeed the criminal cartels that bring problems with the elections, I don't see this judgment creating a scheme of sanctions, incentives, and disincentives that will ensure that going forward, we will have an election that brings more consensus, that promotes national unity and those sort of things.
All right, thank you, sir. Mr. Ward, if I can come to you, what is your initial reaction to this full judgment by the 6 judges of the Supreme Court?
Well, I was very eager and indeed waited with the bated breath how the Supreme Court was going to justify their judgment on some of the decisions that were canvassed during the hearing. And one of them, of course, was the question of nominations. The other one was, of course, the implication of withdrawal, considering that the Supreme Court made a decision in 2013 when they attempted to address, or they addressed some of these issues. I was also interested in hearing or learning how the Supreme Court was to deal with the issue of universal suffrage. Universal suffrage is extending the voting franchise to as many people as possible. Given the turnout that we witnessed on 26th of October, and the fact that 27 constituencies did not vote, how was the Supreme Court going to navigate those issues?
Right.
I think in as much as we accept as a judicial office, I mean, as somebody who is a Democrat, basically, as much as we accept this decision, I think there are certain issues that have not been clarified. And I agree with my brother, Thiankolu Mudomi, that if anybody hoped that with this judgment we were going to secure electoral justice, that with this judgment we were going to fix certain deficiencies within our electoral process, then the truth of the matter is this judgment, in my opinion, was restricted to the validity of the elections held on the 26th, and the difficult task of fixing our electoral electoral process and securing electoral justice is a process that this country must honestly dialogue about.
All right, that is seemingly a position that has been, put forward by the NASA side. But we shall get into that in more detail, as well as some of those issues. Let me get your reactions, Wakili Bwana Kipchumba. Any surprises in there for you?
I think, as a matter of surprises, I didn't see any surprise from the full text of the judgment as read by the Supreme Court justices. But what needs to be noted is that we need to realize from today, moving forward, that most of our political questions cannot be answered through courts or in a legalistic manner. Most of the questions which the petitioners sought were the 14 issues that had been narrowed down by the court. Most of it, the court tried to answer them. But there is the bigger question that remains, is that can we get political answers through the judicial system, which I think political answers ought to be sought in a political context. And there are a few take-homes which I will take home from the jurisprudential text of this judgment, one of it being the issues of locus standi. And it was surprising to me that in the reading of Article 140, which says that a person can file a petition.
Right.
So the question is that now they have widened that to include a juristic person. And to me, I think we should have narrowed it down to a voter. But in their wisdom, they have found it right to include a juristic person, which means an entity can file a petition from where we are now. So I think, and then the other thing will have been the issue of violence in an electoral system, and that you cannot benefit from violence instigated by yourself and come to court and try to benefit from the problems you caused. So I think those are some of the things that going forward, we need to interrogate them with a depth. And also this judgment ought to trigger some electoral reform questions. Because there are questions like the issue that has been raised by my colleague Felix, or the issues of universal suffrage. It was answered well by Justice Moki Nwanjala, but going forward, we need to come up with a policy that will buttress the point.
All right. Let's start there. Thanks for that, Mr. Wakili. Mr. Owar, do you agree with the Wakili Kipchumba there? I mean, the Supreme Court has absolved the state agencies and the IEBC of any wrongdoing in as far as the instances of violence in some areas during the election on the 26th of October are concerned. Does that water down that particular issue?
Well, I'm yet to read the full judgment, and I doubt whether anybody has it. In fact, by the time we came to the studio, it was not yet in circulation. But I will be able to, I mean, the truth of the matter, if we begin by the IEBC, there are a number of issues that the judgment will not address.
All right.
Flowing from the first decision of illegalities and irregularities, and the issues that characterized or preceded the repeat October elections on the 26th, including the resignation of one of the commissioners, Akombe, including the lamentations by the chairman itself that the electoral commission body was under siege. And so on and so forth. Unfortunately, the Supreme Court was not invited to deal with this. And these are the issues that requires a much larger political conversation than the Supreme Court could have dealt with within the 21-day period that they had. The question is, if a body has been found to have committed illegalities and irregularities, the first question, of course, would be, is that body fit and competent to preside over the repeat elections? I think having interacted with IEBC and having looked at IEBC in comparison with their sisters electoral commission, including the Electoral Commission of Ghana, the Electoral Commission of South Africa, I still maintain, and I've been very consistent about it, that this commission caused us the trouble that we found ourselves in, and that we cannot achieve consolidation of electoral democracy without fundamentally dealing with the questions of election management in this country. If you look in every election since 1992, election management body remains one of the democratic deficits of this country. Now, coming to the Supreme Court finding about state agencies and security, I don't know where what the issues were or the evidence that were tabled, but I think it should be apparent to everybody in this country that whereas there may have been political instigation, the repressive and a brutal response by the state agencies perpetuated fear and intimidation. And Article 81 of the Constitution talks about an election that is free from fear and intimidation.
All right.
I'll tell you how it works in Uganda. Mm-hmm. In every election in Uganda, President Museveni deploys massively the military all over, whereas they don't go about intimidating people not to vote. But their mere presence can be perceived to have intimidated the voters, and I think the Supreme Court judges may have overreached themselves, especially in failing to assess the conduct of the security sector and the Kenya police in particular. All right.
What about the fact that they also did talk about the issue of intimidation of the judges? They did say they were not intimidated. There also the issue of Jubilee wearing military fatigue in terms during the campaign. Some of the politicians campaigning for President Uhuru Kenyatta. The Supreme Court finding nothing wrong with that.
I mean, with the Jubilee supporters wearing military fatigue, for sure I agree with the Supreme Court. That is just a choice of clothing that nobody can be faulted about. And I can't see how that potentially intimidated voters from voting. But this is different by, if we compare the security sector, the armed policemen using live ammunition to either quell protest, right, or in a situation such as a 7-year-old boy dies, a 6-year-old girl dies. I mean, even if you want to stretch in political instigation, to imagine that a 7-year-old boy was instigated to carry stones to throw at the police, I think that would be stretching the joke,
right.
quite a bit.
Let me bring in Mr. Thionkolu. So what is your take on the absolution of the state agencies and the IEBC?
For me, it's just a reflection of intellectual dishonesty and perpetuation of impunity, which maybe the Supreme Court is only a reflection of the society that we are, and therefore maybe it is a bit too harsh. But for me, the real concern is we seem to have had this culture. If you go back to the year 2007, the election was largely messed, and nobody has ever served time in committee or similar address for the problems that that election brought to this country. You come to 2013, then the Supreme Court itself says in the 2013 judgment that there was serious misconduct, some of them bordering on criminality and even ordering investigations, but somehow the court doesn't find anyone answerable for this. So along the years, we have some people getting jailed in the UK and whatnot, but in Kenya, nothing is happening. You come to 2017, in the decision of 1st September, we were told the election was nullified because of illegalities and irregularities. Now, these illegalities and irregularities have caused a lot of pain and loss from whatever perspective you look at it to our country and society. Again, the curious thing is nobody is being pinned down to take responsibility from a legal point of view for these illegalities and irregularities. You come to today's decision, we know several people died as a result of the violence, both on the sides of the political players and on the sides of the police. Right. Again, you're told these people have been absorbed. So for me, the question that arises, does it mean these very serious crimes, in my view, commit themselves? There are no human beings who commit them. And that's why I said earlier on when we began this debate that in this country we have perfected the art of legal sophistry. Things that when you read on a piece of paper, they sound very learned, they sound very sophisticated, they sound logical, right, but they're actually covered with a veneer of dishonesty. For me, our country is not going to move forward unless and until, and that's what I meant by the scheme of incentives, as long as our approach is to assume there is some ghost somewhere that is responsible for all these serious crimes, but no particular Mr. X, Ms. Y, who is responsible for it, who will be fined, who will be jailed, who will never get anywhere.
Right. Now, two other issues that were also focused on by the judges of the Supreme Court is the issue of the flag bearer of the National Super Alliance, NASA, Raila Odinga, about his withdrawal from the race, the withdrawal of himself and his running mate, Kalonzo Musyoka. The court ruled that Raila Odinga did not formally withdraw from the election, but only declared his intention to withdraw. Those were the words of the Supreme Court judges. And even if he did withdraw from the election, the move would have not necessitated a cancellation of the poll. That is what the judges said. Let me start with you, Satyankolu.
It's another of those dishonest things, because the truth is the Supreme Court itself is the author of the problem as far as that issue is concerned. Why is the Supreme Court the author of this problem? In 2013, the Supreme Court issued a decision which they didn't have to issue, but they went out of their way to say that, and this is in paragraphs 289 to 294 of the 2013 decision, that if a candidate withdrew from the fresh election, then we would have fresh nominations. So for me, what I expected is an explanation as to what considerations that have informed that radical shift of position from the Supreme Court. Anything short of that, for me, the language of, it's an expression of intent, it is this, it is the things I'm calling intellectual dishonesty. The truth is the court perhaps should be the one taking responsibility for creating the confusion as to the effect of the withdrawal of a candidate in the year 2013. And if they have any reason to think they were wrong then the proper thing to do would be a judgment that says our decision in 2013 was not well reflected.
Right.
It has the following perverse implications, and therefore we are vacating it. But anything short of that, trying to give us legal sophistry, in my view, does not address. It is an act of dishonesty.
Mr. Ward, the court calls it an intention to withdraw. What's your take?
Sorry, I thought Mudomi was still going on. Well, I fully agree with Mudomi. And for the first time, I think the Supreme Court is accepting the reality and the fact that the 2013 judgment had fundamental flaws and has been criticized widely across a number of bars in Africa and a number of, the various judiciaries across the continent. And today's judgment is the first attempt to vacate that decision. The relevant paragraphs that Mudomi has cited, paragraph 289 all the way to 294, the Supreme Court was asked and indeed addressed itself to the circumstances of repeat elections under Article 140 and drew a distinction with elections under Article 138. And the consequences of withdrawal, in fact, in their correction, the correction that they later issued, they even pointed to the fact that a withdrawal would, by implication, trigger a fresh elections. And so one thing that we must admit that going into the August 26th election, there has never been an election that has, the serious confusion and serious uncertainties characterize the electoral environment leading to the 26th repeat presidential election. And so I agree fully that on this particular issue, I don't know what the intention to withdraw is. I don't know it's only the judges who can define what they meant. But I think the confusion was by and large caused by the decision of the Supreme Court in 2013. Very quickly, Mr. Kipchumba, do you agree with the two gentlemen?
I think I tend to take a different view from the two gentlemen because, Mr. Ben, we cannot ask for a greater nation than we are ourselves. And on the matter of withdrawal by Mr. Raila Odinga, I agree largely, to a large extent, with the Supreme Court justices, to the extent that if today I was to announce in a roadside meeting with my elders that I have divorced my wife, does that stand as a real divorce? No. Right. You have to go to court and say that intention, and it meets the threshold as set by court. So therefore, for us to sit down and say that by Raila writing in a letter, whereas we have a standard way of withdrawing, in itself did not meet the threshold set. So therefore, I do not agree. And also, we need to allow or to have institutions have order. We cannot run in institutions whereby everybody writes anything and everything. What if tomorrow somebody proposed to be a candidate and writes the same letter? All right.
Thank you. That was just talking about the reasons why the full judgment by the Supreme Court of Kenya. I was listening to Judge of the Supreme Court, Isaac Lenaola, referring to the issue of nominations, which the court said there was no the new election, the fresh elections, did not necessitate a fresh nomination.
In the fresh election. In all the circumstances, we find no fault with the first and second respondents' decision not to conduct fresh nominations. It was a decision fully in keeping with earlier 2013 and later the Ekuru Court decision. This position, as correctly argued by counsel for the third petitioner, is binding on them at the time. In conclusion, therefore, it is our finding that the first and second respondents, and indeed the third respondent, as well as all the other presidential election candidates, bear no fault as regards nominations and the inclusion of all the August 8th candidates on the ballot paper.
Quickly, gentlemen, I want to get your reactions on this. 40 seconds each on. Let me start with you, Mr. Thiankolu. What is your take on this vis-a-vis the ruling in 2013?
Like we said, Ben, the issue is not whether this decision is technically correct or not, and we can have a debate. Speaking for myself, I actually think the decision is technically correct. My problem with it is the duplicity and what I call dishonesty, because the court seemed to be cherry-picking from its 2013 decision, and even that clip you played must be seen from the entire context. The entire context is the ABC initially said only Raila and Uhuru could run pursuant to the 2013 decision. Right. Then along the way, Ekuru Court got an order which was actually specific to him. Then they included him, then later on they included, and there was all this confusion along the way. Some of the candidates were actually being gazetted on the eve to the election. So that for me, this discussion is not useful. I agree that most of the things the court is saying from a purely legalistic technical point of view are unassailable. My problem with it is why the cherry picking, why the duplicity, why the dishonesty, and the lack of consistency. All right, Yankolu calls it duplicity. Mr. Kipchumba, what's your take?
I'll call it the lack of consistency, but the growth of any democracy in itself grows and flourishes in times of adults and all manner of things. So therefore, I think the 2013 decisions might have had its fair share of issues, but the 2017-2 decision has tried to correct some of these issues. But going forward, we need to develop a robust way of looking at these issues outside what Mr. Thiankol will call it legal sophistry. We need to look at them from a holistic point of view and from a political as opposed to a legal point of view. Because at the end of the day, we might have very many legal positions on these political issues, but they might not answer them adequately.
All right. So what the issue of nominations, it has been discussed at length. What is your take? Anything different in this detailed ruling?
Well, a cardinal principle of law, and especially the election laws, is consistency and predictability. And that is one thing that we actually fault this process. Like I've pointed out, the confusion and the uncertainties that characterize that process was serious. And I welcome every attempt by the Supreme Court to correct and especially vacate its 2013 judgment. But the point is, I mean, to cherry pick, to say this applies and this doesn't apply and things like that, that is to cause more confusion than anything else. And I agree, and like my younger brother there said, that it's a growing democracy. But let's not forget that this country has been independent for 54 years, and we've been a multi-party democracy for 27 years, and it's been 7 years since we promulgated our new constitution. If we don't deal with these issues, with the certainties, the problem is our countries in the sub-Saharan Africa are now fixing their governance problems. And yet, in this country, we still deal with all these uncertainties that characterize our electoral process. And that is my problem with it.
All right, thank you, gentlemen. Stay with us. We'll take a quick commercial break here on The Big Story. When we return, we shall give more, take a more in-depth look at some of these issues. And one of the things the judges of the Supreme Court did say today was that the people or Kenyans who went to the Supreme Court to file those petitions had a right to do that. And we'll talk about that, some argument being fronted by a section of this country that there is no need to go to court or to the highest court in the land, for that matter, for issues of electoral justice to prevail. We shall be engaging the three gentlemen on that issue. Don't go too far. This is A Big Story.